Hello, everyone. I'm Dwight Mitchell. I'm the founder of Family Preservation Foundation, and welcome to our Child Protection Services Pro Se Video Help Kit. Today's lesson is going to be on the out-of-home placement plan, or what most people commonly refer to as the case plan. And I hope you enjoy the content of this series and it helps you better understand your rights and options that are available to you when you're in the midst of a child protection proceeding. As some of you may or may not know, after a 22-month battle, I successfully defeated Dakota County Social Services and got my children returned to me while working a pro se, although filled with anguish and sorrow. I did gain a lot of insightful information, a lot of knowledge as it relates to CPS. Studied a lot of case law, wrote a lot of my own motions, and things of that nature. And I'll be sharing some of that information with you along with the lessons learned while cross-referencing Minnesota state statutes and case law, which is readily available for you on Google Scholar. One of the things that I have to say as a disclaimer is that I am not an attorney. I'm not a licensed to practice law, nor am I providing legal assistance, although I am referencing all legal documents. I recommend you obtain your own attorney if you can, and to review my video series as a companion to help you understand what you need to do when working with your attorney and what's expected as you're going through the CPS process. So many people have told me that the attorneys don't communicate well, they don't understand the timeline or what's supposed to be happening. So I created this series to help the parents that are dealing with CPS. So this series is for educational purposes. I will go over the beginning, the middle, of the end of the entire CPS process and the timeline so that you'll have an understanding of exactly what it is you're supposed to do while you're dealing with CPS. You got to understand that this is going to be some hard work. You're going to have to read. Although I'm giving you pamphlets and handouts and you're looking at this video, there's no substitute for hard work. You're fighting for your children. Your children are the most important things to you as mine are to me, and that you're going to have to fight to get them back. The attorney's not going to do it for you. CPS is definitely not going to do it for you. No one's going to do it. You have to do it for yourself. And so I recommend you to look at the video on your rights and working with your attorney. They're very, very important. So as I give you examples and reference case law and in reference state statutes, you'll have a complete understanding of what is required of you and what you should be going through. You got to remember that you are doing this pro se. Pro se means for yourself. So in that context, you have to understand that you are going to have to do some writing, and you're going to have to create your own filings. Even if I give you an example, you just can't use the examples I give you because every single case is different. They're just there to give you a rough idea of the things you should be saying. Pro se means for yourself, meaning you can't go into court and say that someone else told you to do this. That's not what pro se means. Pro se means you're going to have to do it for yourself, and if you say otherwise, the judge is going to disallow it. Because he's like, you got to either do it for yourself or you have to have an attorney doing it for you. So please keep that in mind as we go forward. So we're going to first start out by talking about the development of the out-of-home placement plan or case plan and what that entails. Technically, it's created by CPS, and when I say technically, what it's supposed to do is it's supposed to be a comprehensive evaluation of the individual needs of the parent and the child as CPS, sees it. It's supposed to do an assessment, and they're supposed to come up with this document based upon, what they have discovered during their investigation of you or your child. So it's supposed to be assessing the needs of the placement, why the child is being placed out of home. The agency has tools that they use. They use a safety assessment. They use strengths and needs assessment. They have a safety plan. So they're supposed to be using all these things to come together and put together this plan that's specific for you, and it's supposed to be different for each individual. Some of the formal assessments that they use might be chemical dependency, a health assessment, a parenting assessment, a trauma assessment, medical and physical needs assessment, developmental assessment. So there's all these assessments that they're technically supposed to be using and sharing with you, so you have an understanding that they aren't just doing this willy-nilly or however they feel. So that's part of the development, and you got to keep that in mind. Don't let anyone just present you a case plan and say, here you go. No, say, how did you derive at that? Let me see the backup, where did you come up with these facts? So there's a lot of collateral content that's supposed to go into. They're supposed to talk with your family. They're supposed to talk with your physicians, the teachers, your school, other welfare staff, service providers. So it's not supposed to be just this, I wrote this up and this is what I think, and that's not a correct case plan. If one comes to you that way, reject it automatically. Make sure you tell the court what transpired and keep a record of everything, as I said. Minnesota State Statute 260C dot 212 says that children that are in placement must have an out-of-home placement plan created for them, and this plan should be prepared by the social services agency within 30 days of that child being taken out of the home and placed in foster care. The out-of-home placement plan means it's a written document. It's not oral, and it's prepared, by the responsible social worker jointly with you, the parent, and or the guardian ad litem. And so it's supposed to be a number of people that are involved in putting together this plan. Now, while the social services person has an obligation to create this plan, you do not have to participate in the creation of this plan unless you've been adjudicated. And we'll go over that in a minute. A lot of people, it's like, well, where's my case plan? Well, you haven't been found guilty. So you have to be found guilty of child abuse before they can make you do this case plan. Please keep that in mind. It's very important. I'm going to go over that a number of times today so you fully understand your rights. And when someone says in 20 or 30 days, I wrote this case plan and you have to do it, no, you do not. That is not the law. So we'll go over that a little bit more in a minute. So getting back to the development, so I digress a little. I don't want to jump around. If a child is over 14 years of age, they have the right to participate in that case plan development with you also. The child's guardian ad litem should participate. If it's a Native American, the tribe or the chief of the tribe has the ability to participate in that. Foster children's parents, if the child is in foster home, the foster family has to know, what they can and can't do and what they're supposed to do according to this case plan, and relatives also. So it's not just one person. So that is something else that you need to know. Now, the case plan must be signed by the parent or legal custodian, the guardian ad litem, the child, if it's of age, the child's tribe, if it's a Native American, the agency, personnel also. Now, you don't have to sign that case plan when it's initially created, but you have to sign that you agree to it. If you go to trial and you've been found guilty or you've been adjudicated, then you should come back, revisit that case plan, make sure you're in agreement, and then have it signed to make sure that everyone whose signature is supposed to be on that case plan is supposed to be on it. Yourself, foster parents, guardian ad litem, the child, if the child's over 14 years, and the chief, if it's from a Native American tribe. So please keep that in mind. So if you refuse to sign the plan when they initially do it in the first 30 days, that's okay. You can identify the parts that are in disagreement. You can go to the court and say, I don't agree with any of this case plan, and that's why I'm not signing. I don't think anything is wrong with me. In 60 days, if we go to trial and you prove something is wrong, then we can talk about me signing the case plan. But I'm not signing or agreeing to anything because I don't think anything is wrong with me. So that's part of the deny. If you deny something is wrong, then there's no reason for you to accept the case plan, especially within the first 30 days, or to sign that case plan within the first 30 days. If you decide you want to work on it, well, that's sort of like saying, well, I think something is wrong, so I'm going to work on it with you, this case plan, where I don't think anything is wrong. Why would you work on a case plan with the counselor if nothing is wrong. After the trial and after you adjudicate it, then you can work on the case plan. So if you have a court-appointed attorney or even a private attorney, that attorney also has the right to participate in the development and creation of that work plan to make sure they're not doing anything illegal. If your attorney can't attend the case plan development meetings, you should try and reschedule the meeting to a time that's appropriate where your attorney can visit at the same time. So as I said, that's Minnesota Statute 260C.121, subdivision 1B and 1D. So please look that up if you want more detailed information on that. So having said that, now we're going to jump to the Minnesota Juvenile Protection statutes, which is 37.02 subdivision 4. This talks about refusal to participate in a development of plan or a disagreement in the services. And this is going to come up, especially if you plead not guilty like it did with me. I'm not signing that case plan. I don't agree with it. I'm not going to do it. So, and they can't force you to do it either before the trial. So when a parent or legal guardian refuses to participate in the participation of the case plan or the out-of-home placement plan, they're the same thing, or disagrees with the services recommended, and I'm going to disagree with everything right off the bat, the responsible social worker has an obligation to notify the court that the efforts that they attempted to do to work with the parents to create this case plan, the parent refuses and the parent is being uncooperative. And, here we go with that word, uncooperative. You're right, Your Honor. I'm being uncooperative. I'm not willing. I'm not in agreement to do this because I don't feel that it's applicable. I don't feel it applies to me. So if you go to court, make sure that if you don't participate, you must go on the record. You must, they're going to submit this plan in 30 days. You need to write an opposition to the plan. Like I said, write an opposition to the plan. And then when they participated, you need to tell the court on the record that you have an opposition to the plan. You haven't had your trial yet, so you haven't been adjudicated. You don't agree with anything in the plan, and that the plan should be stayed or not continued, especially as it relates to you and you doing your services. Because there's services that they have to provide, and that's one of the reasons the plan is done. Like, well, if the child is in foster care, they have to do a medical, dental, school. So there are some things in that plan that they have to do themselves. But anything relating to you, you don't have to do. And please keep that in mind. Don't let them tell you, well, if you do this case plan, you'll get your kids back faster. Flat out lie. That's not the law. I've just told you the statutes to look at. Also, with the juvenile court procedures, 37.02 subdivision 4B, any person, that means you, can ask the court to modify the plan to acquire a different or additional services, and the court may approve the plan as presented by the agency, or they may modify the plan, to either add or subtract required services. That's where your attorney comes in, or you work pro se. This is where it comes in. And the court's approval of the plan may be based upon the content of a petition or amended petition, meaning you have to petition the court. You have to do a motion to say, I want this plan. You can't do it orally, and you have to list why. So for an example, if they come and say, we want you to take a drug test every week on the plan, you say, wait, this has nothing to do with me and drugs. I'm not a drug addict. I'm not going to take a test. You didn't find me guilty of doing drugs. I'm not going to take a drug test. And so you have the right to do something of that nature. They don't have a right to ask you to do things that are obscure just because they want to do it. So there has to be a specific reason for anything that they ask you to do, and it has to be backed up by facts. They just can't say, well, we want you to have a mental exam. Well, what are the reasons? What's your rationale? And you got to prove that I'm mentally unstable. Well, that's going to be hard for them to do also. So the plan has to have state specific reasons for the child being placed in out-of-home placement, including the description of the problem, or what they feel is the problem, or the conditions that cause a child to be removed in the first place. And the child is removed based upon allegations. People need to stop thinking that allegations are facts and that people are saying, oh, well, they're lying. I'm like, an allegation is not a fact. It's not the truth. It's what they're trying to prove. It's what they think, what they see. It's called allegation is at first sight. I don't have the facts, but at first sight, this is what I see. The mother looks like she's drunk or looks like she's on drugs. Well, they have to be able to prove that. The only way they can prove that is if you, agree to take a blood test, which they cannot make you do. So keep that in mind also. We talked about that earlier in another video session. They also have to talk about the foster home, the setting, why they put you in the foster home. Is it a family-like setting? Are there other kids? Are they gonna let your kids visit? You know, if you have other children, are they going to let your other children visit with the child that's in out-of-home placement? Are they going to keep all the kids together in the same foster home? So all of that has to be done in the out-of-home placement plan. And then a description of what's in the best interest of the child. And everything has to be consistent with what's in the best interest of the child. Again, I'm referring you back to Minnesota Statute 260C.121 subdivision C. So you need to, read these statutes. Just Google it. Just Google the statutes. Look at the handout. Do a copy and paste into Google, and then you can read the statutes that I'm providing to you. It's also supposed to include a description of the specific services offered or provided by the social service agency to prevent the removal of the child. So they need to say, well, here's what we're doing to ensure that the child is, not removed or is out of home as little time as possible. And it has to state specific actions that the parent needs to do in order to have the child put back into home or to have that removal eliminated. This is, again, what the social services feels. They have to prove it first. So if they go to trial and prove this, then here's the things they're saying that you have to correct in order for your child to come back home after the trial. Specific services and reasonable efforts or active efforts, if it's an Indian child, to be provided by social services to the parent to achieve a safe and stable home condition so the child can come back home. So that's something else that has to be in the plan. A description of the services or resources requested by the parent or legal guardian. So say you're requesting something, then they need to put that into the plan also. The foster parent, since the child is living with the foster parent, if there's a need from that side, then that needs to be put into the plan. Whether visitation is in the best interest of the child. So sometimes they can say, we recommend visitation, which is 90% of the time, unless it's been a grievous abuse, like a broken arm or something of that nature, or sexual abuse. Sexual abuse, they never allow visitation in sexual abuse cases where there's allegations of sexual abuse. Now, they still have to prove it at the end, but for the first 60 days until they go to trial, a lot of times they will not have visitation, or if they do have visitation, it's supervised visitation. They also should put in when the child can return home or when they anticipate that the child can return home. So that is something that you should be aware of. So when you're looking at this handout that goes along with this particular series gives you all the bullet points, A through M of all the things you should be looking for in your out-of-home case placement plan or your case plan. So they also have to include specific efforts as it relates to the education of your child. Like your child has to stay in school, where they're going to go to school, are they going to go to the same school, they're going to transfer them to another school, and specific efforts by the agency to oversee the child's medical and dental needs. That needs to be in the plan also. You've got to keep your child safe and happy. They should also put in the consequences if you fail to comply with the plan. Fail to comply after the trial, not before. As I said, go look at the state statute. You do not have to comply with this case plan until you have had your trial in 60 days. And then they also have to put in what's known as quarterly assessment. So if you're adjudicated and they find you guilty of abuse and your child is put into foster care and you do have to follow this case plan, they have to have quarterly reviews. Every 3 months, they have to review to see if you're making progress, if things have changed, and what's going on. So there's an and factor also to this, and that and factor is there's a description of the problems or conditions in the home that necessitates the removal. So that has to be in there, that and tasks the parent must complete in order to stop doing the out-of-home placement plan and to get the child to come back, and specific changes that the parent must make and sustain for a specific time frame for the child to safely return home. So say you're doing drugs or an alcoholic, they're going to do tests for 90 days, and you have to be drug-free for 90 days or alcohol-free for 90 days for that child to be able to come back home. So keep that in mind. As I said, a description of the problems in the home of the parent that require the child to be removed. The out-of-home placement plan must be filed within the court within 30 days, as I said, of the child's removal. It must be ordered by the court either as presented by the social worker and technically in combination with the parents and the guardian ad litem and everyone else, or as modified after the hearing. And you got to remember, just because the social worker presented a plan, and you say you were even involved in the creation of the plan, and you might not have an agreement, well, you can go to the court, you can petition the court, and you can say, yes, I was involved, but I don't agree with this. Say she's saying you have to have a test, any kind of test, whatever it is, and it's an hour away from your house, and you got to go 3 times a week, and you have no car. Well, that's clearly unreasonable. And so something of that nature, even if the social worker says, well, you got to go to the test anyway, you can go to the judge and say, Your Honor, I don't have a car. A, this doesn't apply to me because I shouldn't be having a drug test anyway. And B, on top of that, they want me to drive an hour each way. Your Honor, that is clearly unreasonable. And 9 out of 10 times, the court will agree with you, and they'll tell the social worker, you need to find someplace closer to her or within mass transit. Your attorney, if you have one, should inform the court of anything else that the parent needs or that you request or you require for your out-of-home placement plan. And so the court can approve the plan, modify the plan, or completely reject the plan and say, this plan is no good, go back and start all over again. The caseworker, as I said before, might inappropriately develop the case plan without consulting with you, the parent, the foster parents, the guardian ad litem, and present that to the court. You need to stand up right away and write your opposition. Your attorney should write an opposition, and you need to tell the judge that this plan was developed not in accordance with the Minnesota state statute. No one else was referenced on the plan, the guardian ad litem, the foster parents, yourself, the child, and you need to make that known. And in most cases, the judge will automatically reject that plan right away. Again, as I said, if you refuse to sign the case plan and it's filed with the court without a signature, without your signature, and the parent is seen as uncooperative, they can only find you uncooperative, no matter what anyone says. Look at the state statutes, after the trial, after it's been adjudicated. You are not required to cooperate with them until they prove beyond any doubt that you have committed the abuse that they allege with facts. So they got to have hard facts. And 90% of the time, they can't do that without you or unless you agree to it. I mean, if you don't allow them to speak to your doctors or to talk to your lawyers or anyone, then how is they going to get the information? If you don't do a drug test, they can't say, well, you didn't take a drug test, so you're guilty. That's not a fact. That's not the law. People are always trying to prove their innocence. They don't. They have to prove your guilt. It's the other way around. They have to prove their allegations. You don't have to prove that you're innocent. You do that at the trial in your defense. If they say, the person's a drug addict, you're like, no, Your Honor, here's my drug test. That's when you present your drug test at the trial to negate their allegation. Here again, biggest thing I'm going to tell you. The plan can be approved by the judge in the first 30 days. The judge cannot order you to take or to do that case plan until after adjudicated. You have to voluntarily agree to do the case plan prior to the trial, and this is what gets every single parent every single time. The minute you agree to do the case plan, it stops the clock, and now you don't get your trial in 60 days, and now CPS doesn't have to prove their allegations because you've agreed to the case plan, and then you have said, okay, I'll do what you say. You've agreed to it. That, whether you can go to the admit-deny hearing and say, I deny it. But if you agree with the case plan and you agree to do the case plan, quote unquote, to get your child back quickly, well, then you still admitted to it and it stops the clock, you don't get your trial. Minnesota statute 260C 212, subsection D, paragraph 14D. Read it. I'm going to say it again. Minnesota statute 260C.212, subsection C, 14D. The plan can be approved. You do not have to do the plan until after the trial and you've been found guilty and adjudicated, chips, and your child is in need of protection or custody, and that you have, in fact, abused your child. So, if you are adjudicated at trial, in order to participate in the plan, you must keep a journal, keep a notebook, you must do everything that they tell you to do, and you have to get a receipt, a document, a picture, whatever. They're going to try and do whatever they say that you didn't do your plan, and you have to have all of your evidence the next time you come to court that says, I did every single thing on this plan. Do nothing orally. No matter what you do, I'm going to say it again. Do nothing orally. If she tells you over the phone, say that's fine. Send me an email. Send me something in writing. Send me a letter. Then and only then do you do it. Then you acknowledge it. Everything is back and forth in writing so that there's no misinterpretation. If you have one of the iPhones that have the phone recording apps, or an Android, get one of those apps so that every time they call you, you can record your call, and you don't have to tell them that you're recording them. You can always record your own conversations. You can always videotape anything that you're involved in. So don't let someone tell you can't do it. That's not the law. And if someone says, show me the law, then that's just not the law. So document everything, do everything in writing, record all your phone calls, videotape everything, videotape all your sessions. Make sure that you give them no reason whatsoever to say you did not comply with that case plan. So this case law in the PDF handout that talks about in the welfare of the child of SEP, read some of the case law. Once a case law has been approved by the court, and all the motions and the arguments have been taken into consideration, the appellate court finds that plan to be reasonable. So even though you might find it to be not reasonable, if it's been approved after trial, as I said again, after your trial and after they find you guilty, then you have to follow the plan. If it's unreasonable, you can file a motion or you can file an appeal to the appellate court to say this part of the plan is unreasonable, but you have to follow the plan. If you do have changes to the place plan, as I said before, you have to schedule review meetings, and you have to ensure that those meetings are documented. If you have an attorney, make sure your attorney writes everything down. Make sure there's always a follow-up. Say, as a follow-up to our meeting, I'm going to play back what I think I heard, or this is my understanding. And if you do all that in writing, there can never be any misinterpretations. Always bring a prompt motion to modify your plan if you have any concerns at all. Don't wait a week. Don't wait a month. You need to do it immediately. If that case plan comes up, you need to do an opposition or a motion to modify that plan. Ask your attorney, if you have one, if they're familiar with the available services, the service provider, the practice of the agency, or any of that nature, because that'll give you some insight as to what you can and can't do. There are evil social workers. There are some good social workers too, from what I understand. I just haven't met any. So, but I hear there's some good social workers. But I don't trust any of them. And it's not necessarily always a social worker. I have met some social workers that have told me that their hands are constrained. They'll write up a report and their boss will make them change the report or go against what their wishes. And that's, again, for that Title IV V tax dollars. So just, document everything, every visit to the house, everything that's done. Case workers may have a different understanding about a situation than you do. Communication is not always perfect. That's why I say to put everything in writing. You might have one understanding, they might have another. If it's in writing, there can be no misunderstanding. That's why I say don't do anything verbally. Keep in mind that the service providers that they tell you to go to, or anyone they tell you to go to, is being paid by CPS. And that's why I say make sure you document. If you're at a service provider and say they have you taking a blood test or a UI for drugs or something, and that test comes out positive, and you know good and well that you haven't been taking any drugs, you automatically go to the hospital and you get a second test. You go to 2 hospitals and you get 2 tests to cancel out their 1 test. And then you bring that with you so they can't say, oh, well, you tested positive. Say, no, on the exact same day, I went and got 2 more tests by 2 independent hospitals, and this is what they say, your test is flawed. I personally tell everyone, if you can afford it, don't use any of the service providers that the agency tells you to go to. They might come and say, well, you can't use a provider if it's not one of our providers or it's not adjudicated. Well, that's not the law. The law does not say that you have to use a CPS service provider. The case law says you have to get something done. If it's a doctor and it's valid. So never let them tell you that you have to use this. Well, you got to use one that's approved by us. No, you don't. If the doctor's an MD, the doctor's an MD. And don't let them tell you otherwise. So, please keep that in mind. If anything comes back negative from a service provider or a doctor or whatever, make sure you immediately go out and get a second opinion. And I actually tell you to get 2. And because 2 opinions on the same day from 2 different doctors will cancel out that one. And they'll say that one was false. If you have one and they have one, well, there's still doubt. So that's why I tell everybody to go get 2. Back to the juvenile protection court procedures, rules and procedures. We're going to talk about 38.01 social services reports. Those court reports that come out from social services on a monthly basis that are supposed to come to you 5 days before the next proceeding. So the social worker agency is supposed to submit periodic reports to the court that are certified, and it's supposed to list everything that's going on pursuant to the case plan, the children, what you're doing, whether you're following the plan, and there's a timing and a service of that plan, and they have to give you a chance or your attorney to oppose the plan or to make comments on the plan. If they ever give you a plan, at a trial or at a hearing, you automatically object to it. You tell your judge, this plan is not valid. It was supposed to be given to me 5 days in advance, and that plan should be thrown out. The judge cannot listen to that plan because it violates Minnesota state statutes. So you must state that this is against the juvenile court rules and procedures. This case plan should have been given to me 5 days prior to the hearing. If you call and ask for the plan, make sure you send an email or a write-up, on day 5 if you didn't get it, and say, I didn't get my case plan, and don't ask for it again. I mean, not case plan, social services report. And if you don't get it, then you tell the judge, I wrote on this day, here's my email. I asked them for the plan. They didn't plan. I keep saying that. The court report. They didn't give me the court report, and therefore, Your Honor, this court report that they're presenting is not void because it didn't give us a chance to oppose the findings. The 38.11 of the Minnesota rules of juvenile protection, there's a court report that also comes out by the guardian ad litem. Here again, periodic report, review of what's been going on, their meetings with the child, their meetings with you, whether things are going as planned. That's supposed to be 5 days before the court hearing also. If you don't receive that plan prior to 5 days before, here again, you write to the guardian ad litem, say, I didn't receive the court report. Court is in 5 days. Can you please send me a copy of the court report? If they try to submit that report during court, you need to object to that report and say it's not valid. It's against the court rules and procedures, and they didn't send it to you 5 days in advance, and here's my letter requesting them to send it to me, and they didn't send it to me, Your Honor. As I said, in relevant parts, that plan should be talking about the progress made on the out-of-home placement plan or your case plan. It should address the safety needs, permanency, and the well-being of the child. And if it's necessary to get orders for anything, they're going to request orders by the court. If we go to the guardian ad litem's court report, their court report should have a listing of all resources that they contacted as it relates to the child, because the guardian ad litem is responsible for the child and what services the child is going through, whether they've gone to the child psychologist and things of that nature. It's supposed to list the dates and the types of contacts that they've had with the child. It should list all the documents that they've relied upon in putting together that court report, whether they got a report from a doctor or a dentist or a psychologist. So it should be a summary of all the information gathered since the last time they had a court proceeding, speaking about what's been done in the best interest of the child. And it should have a list of recommendations designed to address the child's needs and concerns for the best interest of the child. So that's what the guardian ad litem's report should have. So once again, if you don't get that court report within 5 days prior to the hearing, you request a copy from the social worker or the guardian ad litem. That's the first thing you do. If you don't receive it, you object to the court to the presentation and submission of that late report as it violates the court rules. You can do that in writing, and you most certainly should do it orally and to the judge. Never submit an oral motion if possible. If it's in writing and filed in advance, then the judge has to take it under consideration and an advisement. It's part of the court record, and they just can't ignore it. If you say it orally, they can just say, oh, denied. But they take things more seriously that are written. So I tell everybody to write it if at all possible. There should be a court review every 90 days. That's state statute, so that's the law. And the court review, as I said, should include the social worker's report and the guardian ad litem's report. The purpose, as I said once again, is to review the parent's progress on the case plan and the services being provided, and to determine if they're reasonable, if they should remain active, if things should change, or what should happen. A second hearing must be held no later than 180 days after the child is removed from the home. And it's supposed to go over the case plan in teal. The court is specifically supposed to look at the parent's progress on the case plan if they still have your child after 6 months and didn't release it after the first 90 days, what services the agency provided to the parent and whether they were reasonable, whether the parent was active and participated, the agency's reasonable efforts to finalize permanency or reunification, and whether the parent is maintaining regular contact with the child. And that's very important because you're supposed to maintain contact with your child regularly, 1 or 2 times a week at a minimum, or as much as possible. So at that hearing, the court has options. The court can say to continue with CHIPS for another 6 months, which is something most parents don't want. So that goes to a year now. If the parent has maintained regular contact, they can do like trial visits or home visits. Is the parent making progress with the parent benefit from ongoing relationships from the child should the parent go back home. The district attorney can also file permanency plans. That's a TPR, termination of parental rights, if you haven't been in compliance with the plan after trial and you were adjudicated in another 6 months and you haven't been doing anything. The county attorney can ask for a TPR. The court can start that initiation. So that's if you haven't maintained regular contact with your child, if you haven't participated in your case plan, and they feel the child would not benefit in an ongoing relationship with the parent because the parent acts like they don't care what happens to the child. So with all that said, these are all of the things that go into that case plan, and the judge's options, how often it has to be reviewed, when you need to comply with the case plan. Please look at my statutes. Don't let the caseworkers bully you into taking that case plan ahead of time, saying you'll get your child back faster. That's a lie. That's not the law. And if you take that case plan in 30 days, and just think about what I just said, the case plan has to be turned in 30 days. The first review is 90 days after the case plan has been put in. So if you agree after day 30 to take the case plan, that's 3 months. So that's a total of 4 months that go by before your first review. Well, your trial is in 2 months, where they have to prove that you're guilty. So now you sit here and you say to yourself, self, do I want to do an automatic 4 or go 2 months and have them try and prove I'm guilty? That's what I'm talking about, people. They trick you. They trick everyone. So don't fall into that trap. That's the parent trap. That's the CPS parent trap. That's all I have to say for the day about your case plan, or better known as your out-of-home placement plan. Please look at our other video series. I hope you got something out of this, and share it with your friends. Have them join Family Preservation Foundation group, and I'll see you at the next video series. Have a great day. Thank you very much.